severance pay, how do I know how to calculate what I deserve?
Yeah, it's a pretty circumstantial question, right? There is the legal test for severance pay, and that's based on like the age of the employee, the availability of similar employment, the seniority within the position, right? All the kind of common sense things you'd expect that would raise the amount of a termination claim. Like, for example, if you've been in a job for 1 month, you're not going to be owed as much as if you've been in the job for 10 years. Right? And I think that kind of makes sense to all of us. When it comes to the actual claim amount, first thing that's going to be, a deciding factor is the employment contract. So some contracts will say the employee agrees to limit their claim to only 1 week per year, which is the minimum under the Employment Standards Act. If you've agreed to that in your contract and there's nothing unseemly in the contract, right? Sometimes contracts can have clauses that aren't enforceable. For example, if they require you, let's say your contract had a 1-year probation period. Well, that could make the whole contract unenforceable, right? Because the Employment Standards Act says you can only have up to 3 months. So let's say the contract, everything's fine and everything's legal and all that. If the contract says 1 week per year, that's pretty much going to be your termination claim, right? If there's a discrimination component to the firing, that would be a separate claim at Human Rights Tribunal. But just talking about the termination portion, if you've agreed to 1 week per year, that's what you're going to get. If there isn't something in the contract that limits you in that way, right? You haven't put any agreement in place saying that you'll only take the minimum, then you can go basically for the amount you want. However, there always is, right? In Canadian courts, it's really about restitutionary damages. So paying someone back to get back to the position they were originally in. In the case of a fired employee, the court's basically looking, how much termination pay do we need to pay you to hold you over until your next job, right? Because if this bad thing didn't happen, theoretically, you would be in the job getting paid, and then move over to a new job getting paid. So that's how the court's kind of looking at it, right? They're looking to sort of balance you out during that intervening period when you should have been working but weren't. So if you go into court and you were earning $30,000 a year and you say I'm owed $1 million, you're going to get laughed out of the court because they're going to say that's not what you would have made, right? If you stayed in the job and just switched positions, you would have made your 30,000 over the year, or if it's a 6-month period between jobs, let's say 15,000 or whatever it is, right? The courts are not looking to award people like a lottery win for getting fired. It has to be based on what you actually earned and what you would actually expect in the intervening period before another job. Of course, person doesn't always find a job right away after. So courts will try to estimate, what's a reasonable period, right? You're a senior level employee. All right, reasonably, it might take you 6 to 8 months to find a new job. You're a retail employee. Well, realistically, you may be able to find another job in a month, right? And courts may use that somewhat against you, right? To say you're owed a little bit less. So it really depends on what the situation is for the job, right? And how long you'll take that person to sort of restore where they were before that wrongful termination. And of course, this can be a bit of a catch-22 for employees as well, because if you find a new job quickly, that will limit your termination claim, because the court is trying to restore you right to where you were. So if you leave one job and then 2 days later you get a higher paying job, there isn't really any restoration necessary. You actually did better in that situation. So if you went to court, you'd have to show some other element of the claim, not just that you need termination pay, because that termination pay period was just a few days and you ended up doing better, right? So the court doesn't have anything to repair there to restore for you. So it's a tough situation for employees, but I always recommend for my clients, get a job, right? If you have that option, not like, obviously people have to look for a job, right? But if that option's on the table for you, take it. The court process is very long. Even the tribunals, right, can be a year plus between when you file the claim and when you get a result. Things don't always go as expected. You never know what factors can be brought up by the employer. And there's also a lot of, stress, right, and discomfort going through the process, because, excuse me, you're going to have an employer who's basically saying everything you did wrong, right? Because you're trying to owed all this money. They're trying to prove the other side. They're trying to prove that you're not owed anything. So it can be a very stressful and upsetting process, right? I've had, firsthand experience with clients who they get let go. The employer says, oh, it's because of business. And then once they make a claim, the employer has a laundry list of how they were such a terrible employee and such a bad person and on and on. And it can be very jarring, right? As the employee, once you read this defense or read this counterclaim, oh my goodness, like this person who I had a good relationship with, right? Maybe things ended badly, but generally, a positive experience. And now they're, throwing me under the bus effectively. So there are cases where it makes sense, right? If you were in a steady job that you thought was your career and you were really callously fired or let go, you might have to just make the claim, right? If you, let's say it takes you a long time to find new employment or you struggle to find something new, that anxiety and stress may be worthwhile because you have a large claim on your hands. For many cases, I think if there's an opportunity, if it's between, let's say, a 2-month termination claim and a 1-month claim, but you have a new job, take the new job, right? You're going to be in a better position. You losing that 1 month of claim, that money may end up going to lawyers anyway, right? The process lasts. I'm not saying this doesn't apply to every claim, right? There are certainly situations where it's in the employee's best interest to see it through and go through the legal process. But there are definitely other cases where it's best to get a job. And I do try to generally advise. I would say it's a pretty safe general assumption that getting a job is better than waiting and filing a claim. And the last sort of caveat I'll put on that, if the court finds out that you're purposefully waiting, that can hurt your claim as well. You're able to get a new job and just basically sat at home saying like, oh, well, if it takes me 10 months to get a job, then I get to claim 10 months of termination pay. And if it takes me 15 months, I get 15 months of termination pay. That doesn't really work. If the court finds out you're just sort of sitting around, they can say that you're not entitled, right, to that full period. So it's very important that the employee is actively looking. But if you can bring to the court 100 resumes, you say I've been looking for 8 months now, I sent out 100 resumes, it's a bad economy, it's a bad, maybe my industry is changing, whatever it is, that will be fine, right? The court will say, okay, you were out for 10 months, you were there 10 years, you're owed termination pay.
Wow, yeah.
So I was just going to conclude that generally when there isn't a contractual limitation of that 1 week per year,
right,
general rule of thumb will be that courts will look around a month per year in a valid claim type situation. That really depends on the type of employment, age of employee, length of their tenure, all that stuff. But that's sort of somewhat of a rule of thumb you can go by, right? Around a month per year is usually where you see these cases concluding.
Can you file claims at the 3 different courts at the same time? Can people do that? Can they just file multiple places?
Yeah, so it's a really good question. So you can't file the same claim in multiple places. What people will do is it's all going to be in one forum. So for example, if I have a claim that's a larger termination claim, right? I'm not limited to the week per year by my contract, and there's a human rights component, I'd probably just take that all to court, right? And just claim the damages based on punitive damages or whatever it is. Just keep everything sort of contained in one process. But it is possible, let's say the day before my firing, the employer acts in a discriminatory manner, and then the next day they fire me. You could take the human rights complaint just based on that day, right? Based on that discriminatory activity, take that to human rights tribunal, and then separately, because you were fired, take a termination claim to Ministry of Labor or the courts. So if there's no overlap, you could do it. It does also get into like, would it be practical, right? Because it does, double essentially your time requirements as well, right, to deal with both these processes. But as long as the claims themselves are distinct, you could use the different forms as they're intended, right? So for example, if you were also in that period, you find out, oh, hey, I was supposed to be paid $15 an hour, and my whole employment tenure, I was only paid $12.50 an hour. You could go to Ministry of Labor only to answer that question about the difference, right? That $2.50 of different pay for every hour. Would that be practical? Again, like, you could do the termination there as well. So it may not be the most practical, but it is possible as long as the claims are distinct.
That sounds great. So I think you and I both agree, though, that going to court, whether it's a tribunal or the big court, it really should be your last resort, because those are really very cumbersome processes, and it's not, even if you were to represent yourself, it's just full of anxiety and stress and uncertainty. So it's always best to try to come to a settlement with your employer. So
Yeah,
yeah,
99% of the time, right? There are, like, I
right,
recognize there are those 1% of really horrible things that happen in the workplace, right? So there's
yeah,
really bad employer conduct. There are cases where you should go to the tribunal, you should
right.
go to court to make a claim, but that's a very small minority. If you were fired from a job and it was just, that wasn't a great experience, maybe you weren't there
Yeah.
that long, it's probably going to make more sense to just move on to a new position, for sure.
So thank you so much, Sam, for all this information today. Wow, a lot to digest. And just a quick announcement here: Litigation Help now has a shop. We have guides on how to fill out motion court forms for the civil court. And we also have a recording of a live event, which we hosted earlier, where we had a conversation with Deputy Judge Janice Krieger, and where she shared her insight on being a judge. It was wonderful. And it's up now, the recorded webinar, so you can purchase a ticket to view that. And the link I will put in the description below. Oh, actually, before I forget, so for the recording, for lawyers who are still looking to do their CPD hours, this does count, but you have to be careful when you're claiming CPD, because there are different rules that apply to recorded webinars. So please do check the Law Society website. Finally, if you're new to our channel, subscribe and hit the notification bell so that you won't miss out on our future videos. Thanks everyone for watching, and we'll see you at the next video. Bye.